Fair housing. Fair housing law prohibits discrimination in real estate based on number of protected classes. It covers real estate agents, sellers, buyers, landlords, appraisers, and anyone else involved in a real estate transaction. It's an important rule to follow. It's important that you understand and follow fair housing law and do not discriminate in your real estate practice. As a general rule, you should only talk about real estate when selling or renting properties. And every client of yours should receive the same level of service. Federal fair housing law. There are several important pieces of federal legislation covering fair housing. The Civil Rights Act of 1866 prohibits discrimination based on race. Fair Housing of 1968 extends Civil Rights Act of 1964, protecting to private housing. It prohibits housing discrimination based on race, color, religion, or national origin. The Housing and Community Development Act of 1974 added sex to the list of protected classes. The Fair Housing Amendments Act of 1988 adds protection for people with disabilities, both mental and physical, including HIV/AIDS, drug or alcohol addiction, and for familial status, like pregnancy, or having children under 18 or adoption. The American Disabilities Act of 1990s also addresses the rights of people with disabilities. Under the Fair Housing Act and amendments, there are 7 total federally protected classes: race, color, religion, national origin, sex, disability, and familial status. Disability protections. After March 1991, all new and renovated residential 4+ unit homes must have adaptable design features for the first floor and any floors serviced by an elevator. Landlords must allow reasonable modifications of residential rental properties at any time during the tenancy. For example, using a ramp to get into a building. Tenant may be required to pay for any needed modifications, such as grab bars in a bathroom or lowering countertops. The landlord can require a tenant to return the rented property to its original condition when they move out, again at the tenant's expense. Under the Americans with Disabilities Act, commercial properties built or renovated after 1991 must also have accessible design features, since businesses that occupy them and are open to the public will qualify as public accommodation. Brokerages fall under a place of public accommodation and should always comply with all laws regarding fair housing and ADA accessibility. Business tenants will also need to comply with ADA requirements if they have 15+ employees. Different types of businesses may also have special additional ADA requirements. Both landlord and tenants are held responsible to be compliant under these laws, though commercial leases will often spell out who is responsible for exactly what part of what in the compliance. Those with disabilities are permitted to receive reasonable accommodations, such as having parking spaces close to the front entrance, adjusting rent pay periods to match their income assistance, or having assistance animals. If an applicant requests an accommodation, a property manager or landlord has the right to ask an applicant to verify the accommodation or modification is needed in order to enjoy equal access to the housing program. Tenants with disabilities can adjust the date their rent is due, but the change must be in writing with the landlord. Disabled tenants and property owners must be allowed to have assistance animals. Pet policies, condo breed restrictions, pet deposits, etc. do not apply to these animals. There are two different types of assistance animals: service animals, who are trained to perform a task, and support animals, which are any animal a health professional, doctor, social worker, has deemed to be an emotional support animal. Both types of assistance animals must be permitted in housing, though the rules surrounding documentation are slightly different. If an applicant uses a service animal, a landlord or a condo association is entitled to ask only two things: if it is a service animal and what task it performs. The landlord or condo association is not entitled to documentation and must not ask those questions if a person's disability is obvious. If the animal is a service animal, the service animal must be allowed, no exceptions. Under ADA, service animals can only be dogs, or when reasonable, miniature horses. If a person has a support animal, a note from a health professional can be requested, but not the reason the person needs the animal. But disability must never be mentioned. If a note from a healthcare professional is provided, the support animal must be allowed, no exceptions. Support animals can be any animal approved by a health professional. Disabilities are not simply limited to mobility issues or physical disabilities. Individuals with AIDS, alcoholism, recovering from drug addiction, or mental illness are also protected under the ADA. Massachusetts protected classes. Massachusetts fair housing laws build on federal fair housing law. It prohibits the same discriminatory behaviors and also adds additional protected classes. Discriminatory advertising is also prohibited under the Massachusetts Fair Housing Law, under MGL 151B. The Massachusetts protected classes are age, sex, marital status, sexual orientation, gender identity, gender expression, veteran status, race, color, religious creed, public assistance status, ancestry, disability being mental or physical, genetic information, national origin, and familial status. In homes with lead paint, discrimination against potential tenants with children under the age of 6 is always prohibited as well, with no exceptions. If there is lead paint, the landlord must de-lead the home and cannot refuse to rent tenants with children under the age of 6. Effective October 2022, Massachusetts passed the Crown Act, a law extending protections against racial discrimination to include protection from hair discrimination based on natural or protective hairstyles. It protects traits historically associated with race, including but not limited to hair texture, hair type, hair length, protective hairstyles such as braids, locks, and twists, bandeau knots, or hair coverings. Disability protection in Massachusetts. Under the MGL 151B 804 CMR 2.03, all public housing and landlord within 10 plus units must provide modifications at their expense for persons with disabilities. They are also required by law to permit service and support animals. As of March 1991, any new residential construction for 3 plus unit homes must include basic access to public paths, public areas. Wheelchairs must be able to fit through the doors and inside of the unit, and kitchens must be able to provide ample space for maneuverability. Public assistance programs. Public assistance is protected under Massachusetts Fair Housing Law, without exception. It covers people receiving housing assistance as well as other government assistance, for example, food stamps. Real estate agents cannot refuse to work with someone because they are receiving public assistance, and landlords and sellers can never discriminate against someone based on their use of public assistance. The source of someone's income is not a factor, only an ability to pay. You should be familiar with two major housing assistance programs. Mass Housing, an independent quasi-public agency created in 1966 that is charged with providing financing for affordable housing in Massachusetts. It provides financing for affordable housing construction, oversees affordable housing developments, and provides low down payment and affordable loans to first-time home buyers. Section 8, a federal program designed to provide renters with affordable housing via a voucher system that subsidizes rentals provided by private landlords. It is a program for assisting very low-income families, the elderly, and the disabled in the private market. Participants are not limited to units located in subsidized housing projects and are free to choose any housing that meets their requirements, decent, safe, and sanitary within the program. Local public housing agencies, PHAs, administer vouchers to eligible families. Eligibility is based on the total annual gross income and family size. The family income must be under 50% of the median income for the county or metropolitan area in the area that they choose to live. Once the family is found to be eligible and PHA approves the housing unit, not only do the landlord and family sign the lease, but the landlord and the PHA sign a housing assistant payment contract that runs for the same term as the lease. While federal law does not require landlords to accept a Section 8 tenant, Massachusetts law does require landlords to accept a Section 8, the Massachusetts Rental Voucher Program, and Veterans Affairs Supportive Housing programs. Massachusetts landlords can screen a prospective renter for everything except income. Properties must be at or below fair market rent for the area, 90 to 100% assessed by HUD, and inspected prior to tenant occupation. The government's portion of the rent is directly deposited to the landlord, but any additional owed rent must be collected by the landlord. Annually or biannually, the landlord must have the property re-inspected, and the tenant must recertify their income and assets to remain a part of the program. While Section 8 doesn't specifically cover utilities, if they are included in the rent, then the payment vouchers will take those costs into consideration. Other types of public assistance programs include social welfare programs and social insurance programs. Note that these are not the only housing assistance programs in existence, but they are the most common ones that you might encounter. In some states, a landlord must agree to the request for a different due date if the tenant's main source of income is from the government assistance. However, if the majority of the income comes from other sources, the landlord is not required to change the due date. Prohibited activities. Under fair housing laws, agents, sellers, buyers, and others involved in a real estate transaction must never discriminate against someone on the basis of one of the above-mentioned protected classes. Examples of prohibited behavior include refusing to work with someone, differentiating on terms or conditions, advertising in a discriminatory way, for example, no children, falsifying availability, engaging in blockbusting, which is any solicitation of a property for sale or lease on the grounds of an alleged change in property values due to the presence or prospective entry into a neighborhood of people covered by a protected class. It creates panic selling, known as panic peddling. In plain English, if someone is potentially guilty of blockbusting when they talk about property values in relation to people living or moving into a neighborhood. Historically, this practice was especially prevalent in the 1950s and 60s when real estate agents in predominantly white neighborhoods would spread rumors that Black families were moving in. The real estate agents would then buy departing white families' homes at discounted prices and sell their homes to Black clients at much higher prices. The agents would then use those sales as evidence to induce more white homeowners to sell their properties to real estate agents at discounted prices and repeat the process, steering prospective purchasers or renters away from towards certain areas based on a protected class. For example, a real estate agent suggesting certain neighborhoods to a client because of their race, or declining to show a client a particular neighborhood because of their race. Using covenants or restrictions to limit occupancy based on race. A notorious example of this outlawed practice occurred in Levittown, New York. Many of the original deeds for the homes sold in Levittown included a stipulation limiting ownership of the property to members of the Caucasian race. Prohibiting someone from joining a professional real estate organization or inquiring about anything in regards to a protected class. Where are you from? Are you having any children? Exemptions from fair housing laws. There are some exemptions from fair housing laws for real estate owners that you need to know about for the exam. It is crucial to note that these exceptions are never allowed for discrimination based on the basis of race. In Massachusetts, exemptions are also never allowed for the discrimination based on public assistance status. It's also important to note that real estate agents must always follow fair housing laws. They are never exempt, even if the owner is exempt. Fair housing laws also always cover advertising, even if the property being advertised is exempt. The only exception to this rule is if a roommate is seeking a same-sex roommate in the event that they are living in a shared space per Title 24 Code of Federal Regulations. If a property owner who is exempt from fair housing laws wishes to use a real estate agent, they cannot make use of this exemption. If they wish to make use of the exemption, you cannot represent them. So while you must know these exemptions for the exam, they will never be a part of your real estate practice. The following situations are exempt from fair housing protections, with the exception of race and public assistance, which are always protected and have no exemptions. A private individual who owns 3 or fewer single-family houses, provided they have not sold more than one property in the past 12 months. Rentals in owner-occupied 2-family homes in Massachusetts and 2 to 4 family homes elsewhere. Housing provided for non-commercial purposes to members of a religious organization, assuming that membership in the religion is not discriminatory. Housing provided for non-commercial purposes to the member of a private club, so long as housing is never open to the public. Roommates are usually not covered by fair housing laws, so as long as real estate agent or management company is not involved in the search. Penalties under fair housing law. Any person may file a fair housing complaint with the Department of Housing and Urban Development within 30 days of the date of an alleged discrimination and have up to 2 years to file a private lawsuit. Fair housing discrimination complaints may be proven by testing, which means that the enforcement agency may send people out to test the accused landlord or real estate agent in order to prove a pattern of discrimination as a result of those interactions. For example, a landlord who has been accused of racial discrimination in renting a property may have a non-white For example, a landlord who has been accused of racial discrimination in renting a property may have non-white agents posing as potential tenants to see if the landlord discriminates against them. These testing situations are not considered entrapment because the landlord is not tricked into doing anything they would not normally be doing. They would be simply being tested for existing discrimination. Penalties for fair housing law violations are severe. HUD administrative law judge can fine up to $21,000 for the first violation of federal fair housing law, $54,000 for the second, and up to $108,000 for repeat offenders, in addition to civil penalties between $500,000 and $100,000. In addition to this, or in lieu of a complaint to the HUD, a lawsuit may be filed in federal court within 2 years of the alleged discrimination, in which there are potential criminal penalties and no specifics on damages. In Massachusetts, findings against an agent by Massachusetts Commission Against Discrimination will result in an automatic license suspension for a minimum of 60 days. A second violation will result in 2 years. A second violation within 2 years results in an automatic minimum 90-day suspension. A HUD equal housing opportunity poster must be posted in every real estate office. The same is true of the MCAD fair housing law poster. Failure to post these posters represents a prima facie, or presumed to be true, evidence of discrimination. And that is fair housing law.